Good evening, sir. With your kind permission, can we start, sir?
Yes.
Good evening to everyone present here. I am Amin, volunteer of Sambhav Initiative and moderator for this event. On behalf of organizing committee, I extend a warm welcome to our esteemed dignitary, Dr. Prashant Amin, sir, and to all the participants in this 2 weeks online national capacity building program on art of contract drafting from fundamental to enforcement, organized by Sambhav Initiative, which is working towards alternative dispute resolution, free legal aid, mental health, and creating legal literacy under the direction and guidance of Patron Chief of Sambhav Initiative, Honorable Justice C.K. Thakkar, sir, former Judge of Supreme Court of India, and Patron of Sambhav Initiative, Honorable Justice M.R. Shah, sir, former Judge of Supreme Court of India, in collaboration with Pro Bono India, which is working towards legal aid and legal literacy. Where today's session is all about franchise, distribution, and business expansion agreement. Before we start the session, please adhere to some webinar etiquettes. I request all the attendees to keep their microphones muted during the session. If you have any questions, please use the chat box or raise your hands. It is our privilege to have with us an honor to introduce Dr. Prashant Amin, sir, an accomplished academician and researcher, currently serving as an assistant professor in the Faculty of Commerce at the Maharaja Sayajirao University of Baroda. Sir brings with him a rich blend of academic rigor and industry experience with specialization in commerce and business management. Sir holds a PhD in management from Sardar Patel University, a Masters of Law from MSU Baroda, where Sir was the top graduate of his class, and an MBA in marketing from Veer Narmad South Gujarat University. Sir also holds multiple postgraduate diplomas and certifications in specialized domains such as cyber law, industrial relations, and financial management. Before joining MSU, Sir held academic positions at renowned institutions like GSFC University and Parul University, and also gained valuable corporate experience in managerial roles at Inox India Limited and Elecon Engineering Limited. This unique combination of academic and industry exposure allows her to bring practical insights into the classroom. Sir is a published author and editor with notable works on legal and business subjects, including comparative advertising and product disparagement and reimagining business management in the 21st century. His research contributions span topics such as digital marketing, consumer behavior, OTT platforms, and advertising law, with several publications in UGC, CARE listed journals, and international conferences. A dynamic educator, Sir is known for his engaging teaching style that bridges theory with real world application. Sir has mentored numerous students, guided internships, and actively contributed to curriculum development, seminars, and research. We are deeply honored to have you with us today, sir. Over to you, sir.
Thank you so much. Thank you so much. First of all, I would like to, thanks to the Kalpesha and the organizing committee. Hiranshi ma'am also, she was my classmate at the Faculty of Law, and entire team members of the, Pro Bono Consulting and Sambhav Initiative. So the topic which, today we are discussing, rather we are looking to the the main issues which we are dealing with the franchises distribution and business expansions. So now if we let me start this, I think my screen is visible, PPT is visible.
Yes, sir, it is visible.
It is visible, right? So let me start with the one of the small story of the franchises where there are two. Let me come to the second slide. Okay. Once upon a time, in a busy town, there are two bakers, Arao and Kabir. And they traded goods with the simple handshake, and the trust was their currency. But one day, Kabir delivered and spoiled the floor, and Arao's customer vanished. The trust broke. The mistrust began to spread. As soon, the traders doubted everyone. One of the powerful merchants then brought all the flours mill in the particular city and fixed the high price. And that's a problem of antitrust problem. And people cried for the fairness. The king stepped in and introduced a contract law. Every promises had to be written, signed, and legally enforceable. Years later, the Arrows Bakery became the famous that he allowed others to run the shop using his name and the recipe. He used the contract to grant this right, creating the first franchises in the land. Now, the last line which says that from the broken trust, there came law. And from the law came the new business opportunity. So now if you look at the contract law from my perspective, then my perspective is nothing but we are not trusting to the other party to whom we are doing the business. And that is because of there is a need for law. And in the category of the law, we need the contract law, right? So it is basically we are fixing the trust, and that's how we are entering into the contract, right? If we look at the this contract law, I mean the franchises is a genre of contract law. So how this particular franchises word has come? What is the etymology of the contract and the franchises? It is the Latin word from contract here and the old French word franchises. The meaning of the contract is to bring together. Together we conclude the bargain, where the franchises means meaning of freedom and exemptions. While in the contract is an English word and Latin word, the francus for the franchises. In the English word, which we call as a franchises. If we look at the franchisee, which means what? It's basically the liberty. In the Middle French, the franchir means to free. The Old French, it is called franc. That is also free. The another French term is a francis, means granting the right or power to the peasant or serf. The English term enfranchise, which defines as empowering those who have no right. And the royal teaches in predecessor of royalty and originated as the practice of certain Englishmen receive the percentage of land in the fees paid by the nobility. In that, this is the story when there was a royals and they are ruling and they are giving the certain rights to the the people to do the commerce, freeing the commerce from the traditional chain. So that's how this particular I think this much of the information is helpful as far as understanding the word, why the franchises and not the any kind of a legal kind of a word. Like legal word is a contract, but not the contract between two parties and those kind of things. If we look at in US, it has a very interesting story. I mean, if you look at the last point number 1, then one of the gentlemen called Kroc was the Kroc is visiting the McDonald's stores for his juice milkshake mixture needs. And over a period of time, when Kroc has done the business with the McDonald's, then over a period of time, Kroc ensured and he asked the licensing with the McDonald's, the exclusive right to market the McDonald's name and the method. If you look at it, point number 3, how this is the development, how the franchises was evolved in US. Then in the first franchises, the Kroc opened the first McDonald's store after receiving the license in Illinois. And fourth, when over a period of time, he acquired the land and purchased the future franchises locations. And then fifth point, which says that the franchises over a period of time expand and it grows 37,100. And then there are 228 localities by 1961. And the Kroc becomes the senior chairman of the McDonald's in 1977. And now, if you look at if you compare in 2025, the McDonald's is, presenting in every corner of the world. So this is how, the particular business is evolved. If we look at the first word of the topic, which is allotted to me, and that is called, what are the issues related to the franchises. So I suppose you can see this particular slide. If you look at from from the left hand side, which are the legal issues evolved. So when there is a franchise kind of a contract, then there are issues related to the intellectual property right, consumer protections, tortious right, weight and measurement rights, and so on and so forth. I mean, I'll discuss how I have designed my presentation. From this slide, I have taken the particular cases, and that particular cases in the legal era, it is arising out because there is a flaunt into the clause constructions, and the statutory interpretations between the two parties, those who are entered into the business. Maybe it is the clause related to labor, maybe the insurance or e-commerce or validity of the franchises or the agencies, or maybe intellectual property right related. If it is a product, then it is related to the weight and measurement also. Because one of the famous case is in the Bombay High Court, that the pizza which is served at the different outlet with the different weight and measurement, if I am spending as a customer 100 rupees, then I should, according to the weight and measurement act, I need to get certain quantity of the food items. So that is also, there are legal challenges in those kind of things, right? So I presume that you remember these are the areas where these are the touch points where the legal issues arise, whether it's a franchises, if there is a distribution kind of a contract, only the product is being distributed to the other city or the villages or the suburban area, then these are the issues is related, right? Then my presentation is divided into, first part is legal issues I'm discussing, and then the cases. Case brief, what are the issues involved and what the court has said. Second part, as the this particular initiative is done regarding the drafting of the contract. So I'll show one of the contract where what are the things you need to keep into the mind. Now, if you look at the I will discuss the different cases here, and then we'll see the how the drafting to be made, and last I will discuss two of the landmark judgment of the Supreme Court of India, Honorable Supreme Court of India, and then we can understand that how this particular franchise is operated, right? And this legal issues, when we are you can look on the look on the slide, these are also the legal issue arising out of the imperfect, or I would say the the two parties, one party has forgotten to mention something and the legal issue is arising out of it, right? So that is that. And in the first slide I told you that it is because of the trust. I mean, all the contract act, if you look at from the overall point of view, then it is arising out of the issue of the trust. When the trust is broken, to fix those trusts, there is a contract, right? I think I made myself very clear, right? Now, if you look at this particular Indian cases, cases arising out of the validity of the franchises. If you look at this previous slide, right? In that previous slide, there is a validity of the, just a minute, I'm not able to. Okay, so validity of the franchises. So there is one particular case called Gujarat Bottling Company Limited versus Coca-Cola in 1995. The Supreme Court had decided. What are the issues involved? The issue is franchises agreement and negative covenant. The Supreme Court held that the validity of the franchises agreement and recognize the negative covenant, exclusivity, which things to be excluded and which things to be included, that is to be valid, and when it is reasonable and when it is not reasonable. Then there is a validity of the franchises, whether the particular franchises is valid or not. Second case in the validity of the franchises is Modi Entertainment Network and WSG Cricket Private Limited. The Supreme Court is, what is the issue? The enforceability of the exclusive right into the media of the franchises, right? Something, during the cricket or IPL and those kind of things, that time the TV or the channel has a certain right to broadcast these certain events. So that kind of issue, and the franchises, earlier agreement shows that I will only broadcast this particular IPL from this entertainment network. So that kind of issue, enforceability of the exclusive right into the media franchises. And what Supreme Court had decided? The enforcement of the franchises right under the Indian contract law, right? Then agency related. I'm not doing anything, new. I'm just, what are the legal issues? See, you can see, if you can see, what are the legal issue? Agency related issue, for example, agency related issue. The agency related issue, the Sayyid Abdul Khader versus Rami Reddy in 1979. What is the issues involved into this kind of a contract? Then the nature of the contract is principal agent relationship, right? According to the contract act, the master servant relationship and how the agency is operated, right? So the importance to explain the scope and the responsibility of the agent. What are the responsibility of the agent? Because every act of the agent is done by the masters. So that is a kind of a agency kind of a contract. Then the business context, like distributions of the franchises, right? So that is a agency related issues. If the clause related to the agency is not properly framed, then what will happen? This kind of issue is evolved, right? Compensation, competition law and MRTB, monopoly restrictive trade practices issues clause, if it is necessary. Mostly this kind of a clause is in the when the foreign companies like Pepsi, Coca-Cola, or Hyundai, or Kia, or that kind of a company, when entered into the contract with the government kind of a thing, right? That time the government is looking to the competitions law, right? So in that Competition Commission of India versus Steel Authority of India Limited, that case the issue is abuse of dominant power and anti-competitive practices, right? The Supreme Court has decided and gave the judgment that landmark case, which is laid down that the procedure for the competition investigator relevant for the franchises for the dominant market power. I think I still not remember, but the Competition Commission of India, I think Section 7, abuse of dominance of power, Section 7 or Section 10, I forgot the exact number, but there is a one in Competition Commission of India law, there is one particular clause called abuse of dominance of power. So that is on that basis, one particular company is entering into the business and he's controlling the entire market, which is against to the laissez-faire. Laissez-faire means the market is free market, and free market in which the any company can enter, any company can close the business, any company can wish to launch a product which is legally admissible as far as the law of land is concerned, right? So that was the case, right? So this is if the competition clause is attracted, and if the two parties has made this kind of a competition clause, then also it is a matter of dispute. So from the contract drafting point of view, which are the things we need to keep into the mind? From that perspective, you are supposed to understand these cases. I hope you understand. And then we'll see the one of the contract drafting, right? MCX Stock Exchange Limited versus SEBI. The issue is related to the monopoly and the entry barriers. Now we will look at this monopoly and entry barriers. Here it is discussed how the regulatory barriers affected the fair competitions into the relevant for the market entry during the business expansion. So this case is related to the business expansion. Our topic for the discussion is franchises, distributions, and another is a business expansion. So this particular case, MCX Stock Exchange Limited versus SEBI, is related to the business expansion. Okay, to what extent the particular business can be expanded as far as the Indian law is concerned, right? Then next slide, the consumer protection liability clause. The case is Indian Medical Association versus Shanta in 1995. The Supreme Court, the issues involved applicability of the Consumer Protection Act. And what is the importance? While primarily about the medical services, and it is clarified how the consumers applies to the franchises dispute too, right? So that particular case is related to the this just a minute, my slide is not moving. Just a minute, just give me a second. Just give me a second. Okay. So this Consumer Protection Act, and then there is a case of Spring Meadow Hospital, Herzog Ahluwalia case, where the franchises is a liability towards the customer, and the importance to recognize the consumer right even in the service provided under the franchises and agency model. So that is a consumer related clause. Intellectual property right related clause cases, Dunlop pneumatic tires, and it follows the trademarks and franchises right. Importance is the foundations of the IP licensing, intellectual property right licensing, and the brand use into the franchises. And then Milmet Ofo Industries and Elegran Incorporation in 2004, the issue the trademark protection across the border. And importance is for the franchisers, the international brands operated in India, right? So that is the case. Then there is a recent issues related to the e-commerce. So e-commerce related clause, the Amazon service, very landmark judgment. Amazon Sailors Service Private Limited versus Amway India Private Limited. The issue, the e-commerce and the parallel distribution. The importance is, the landmark judge, the Delhi, this is one of the landmark judgment, and where the Delhi High Court said that the online marketplace and unauthorized selling, if another person is selling and unauthorized sellings are there, then who get the franchises distributions right? So that is also e-commerce related clause. If our product and the services as a franchisors falls into the category of the e-commerce clause, then there is a corporate security clause. That this is, I mean, not applicable as far as local kind of business is concerned. But the one of the cases, Tata Consultancy Services and State of the Andhra Pradesh in 2004, the classification of this software as a good, and it is affected the franchisees selling the software and the services and how they are treated under the tax and corporate law. So if the agreement is not mentioned specific term of the corporate and security clause, then this kind of issue may be arise, right? Then labor related clause related to the bank. This is very famous case of Industrial Dispute Act, where Bangalore Sanitation water supply, and A. Rajappa, where the definition of the industry under the ID Act has been expanded, and the impact whether the franchisee unit is covered the industrial labor legislation or not. I mean, labor whom we are recruiting as far as our franchises is concerned, that particular labor is the part of the agreement or not, or what effect we can give, right? So that is the labor clause. Then there is a tax cases, McDonald's India Private Limited and Commissioner of the Service Tax in 2007, the service tax on the franchises agreement. The importance is clarify the franchises fee is taxable in services. And State of the West Bengal and Keshoram Industry Limited. This Keshoram is a very famous case, where the scope of the tax business activity, the importance is discussed in this particular case, constitutional power to levy the business tax and applicable to expanding the franchises. Then there is an insurance clause. The landmark judgment is, the LIC of India and Consumer Education and Research Center, 1995 case, where the right of insured customers, and the court has said that the significance of the franchises model offering the insurance service or the policy, so how we can give the effect to those. Then there is an exchange control clause, mostly the foreign company which is entering into the Indian soil and they are doing the business. So that time this particular foreign company clause is being FDI, foreign direct investment, and cross-border business expansions can be attracted, right? And then there is a tortious clause, like Jai Lakshmi Salt Works and the state of Gujarat, where the negligence by the state of the third party and applicable to the tortious liability by the franchises. And if there is a property related clause, property owned by the person who is owning the franchises, or property owned by the the main business owner. So that is also the particular liability which is being affected while my battery is running down. Okay, let me just, okay. So how this particular property clause can be attracted, right? So in this, the abuse of dominance of power in real estate, that is the case of Competition Commission of India. I mean, this abuse of dominance of the real estate power, that is property related clause. Then weight and measurement clause. Just now I have discussed one particular case of the Bombay High Court where the weight of the pizza is being challenged because the other pizza outlet, XYZ competitors, they are selling and giving the materials in the pizza in different quantity. And that particular weight and measurement clause, if it is applicable to the franchises or distribution agreement, then that is also for the considerations, right? Then let us understand now second part of my presentations, the fundamental aspect of drafting and enforceability of the franchises agreement. In the franchises agreement, it is legally binding contract. It is a legally binding contract. It outlines the terms and conditions and governing relationship between the franchises who is having the brand power and the franchises who is operator, right? So which are the categories of the franchises? I mean, we are not going into the detail of the category, but you can see on the screen that, the characteristic, product distributions, manufacturing of the product and business format. And here on the left-hand side, which are the product source, if the product source is, and how the product distribution can be done. So this particular grade, if you look at, then what is the characteristic for product distribution and product source? Then the franchises manufacture the product. If the sales target and the product and distribution, then sell the consumers. Then so on and so forth. So I mean, this is the just a comparison of the franchises category, right? Then how to ensure the clarity into the franchisee agreement. So there are 2 points. I mean, in this, if you look at the screen, then there are 2 points. One is you need to first, whether it's a franchisee clause or the distribution clause or the business expansion kind of a thing. First thing is identifying the parties. Clearly state the legal names and the address of the franchisors and franchisees to avoid the confusions. Second is the defining the key terms. Key terms means the terms like franchisee agreement, whether it's a marks to prevent the ambiguity. I mean, this is the key terms of what is the nature of contract. I mean, the second point which says that defining the key terms as far as our, according to the business. I mean, if it is a Coca-Cola kind of a thing, then the soft drink business. If it is a, food delivery, then it is a different business. If it is a tea kind of a thing or tea post, and that particular franchisee has a different model. So according to that, we need to define the, key terms as far as the agreement is concerned. Now, second point is this particular contract is arising out of the right. I think, in the first slide, slide, I told you that one particular story, and that particular story is related to the trust. Basically, the trust is, the issue, and that's why we are having the contract law. So then there are the issue of related to the rights. Then what rights should be granted to the franchisors? So first is a trademark. These are the important rights which I have prepared for the purpose of understanding. That is one is a trademark is a very important clause. Then how we are operating the system. System means business processes we are talking about. Then in which geographical area this particular distribution or franchises can be operated, and the territory in which this particular right can be granted. So when you are drafting the clause, that time you need to understand these four most important, I would say, the essential clause of the franchisee or the distribution contract. Then another thing which is important as far as this contract is concerned, then the renewal terms. First is the how much initial durations are there. Specify the agreement's starting lengths and renewal conditions. Which are the renewal conditions? Any kind of a fees or the royalty or the payment to be made or not. So that is the two most important link, which is starting point is the initial durations, and renewal conditions, that is another starting point if the company or the business wish to continue with the same franchises. So that is a initial durations and the renewal conditions, right? So that is the idea. Then what are the financial obligations during the contract? This four clause is during the initial durations works. Initial duration, specify the agreement with stating the land. So in that, the most important thing is the financial obligations. So first financial obligation, what is the initial franchises fees, right? Upfront cost to start the franchises and ongoing royalty. Second is ongoing royalty. If the regular payment is to be made based on the sales, linked to the sales, irrespective of the sales or the profit or the turnover, whatnot. Again, it's depend upon the understanding between the two businesses, right? Then there is a who will do the advertisement contribution, fund allocated by the advertisement and the marketing effort at the city level done by the person who is owning the franchises or the company which has the franchises, which is giving the delegating the particular franchises. So that cross advertising contribution is also has to be defined, and there are other fees if it is applicable, additional charges and the service and the equipment. So that is also defined, right? Then if you look at the operational manual structure, the effective business operations, where the quality control is important, because when you are delegating the product and the services in terms of the franchises, then ultimately you are giving your technical know-how to the other party, and the quality is most important part. What kind of a quality is to be maintained. And if you look at, if you take the example of this McDonald's, then I don't know how many of you are aware that their frying of the patty in the burger, that manual is 1200 pages manual, and that is circulated to every franchisee holder. And they have to fry the particular patty into that particular temperature and the ingredients and those kind of things. That's a quality control. If you go into the detail of the quality control of the product and the services, that is only one part. Like that, whatever is the ingredients into the particular product, what cares to be taken by the franchises holder, that is the quality control part. Then there is a customer service, the delivery exceptional of the clients. Okay, how we are going to have the customer service, whether it's a third party service like a Zomato and those kind of things, and other third party can be allowed or not, because it is also related to the brand deterioration. So that the business is also, when we are drafting the contract, then we need to understand that strictly the Zomato and other service can be prohibited or not to be prohibited, and those kind of things, right? So that is the idea, right? So next is the marketing strategy. This is, another domain, so we are not discussing, but marketing strategy related clause, that is a brand promotions, and who is taking care of the entire brand promotions in the city or the state level, and the brand compliance aligned with the company's brand compliance. Like a Titan has a certain company showroom, and other is the retailer kind of a thing. So how we are managing those kind of agreement, right? So that is the idea. Anyway, then another IP related issues like trademark. I'm not going into the I'm sure that this the trademark use, how to use, what to use, when to display and when not to display. So that is clearly defined into the contract. That is a trademark term. Then there is a copyright protection. Who how much the particular franchises holder or the distributor can copy the logo or the brand or the tagline or the kind of a
Participant, please wait for a while. I think someone disconnected. Sir has got disconnected. Participant, please wait for a while. We're joining soon. अभी सर ज्वाइन कर रहे हैं?
Yes, sir. Sir is joined with the name iPad, sir.
iPad, ओके चलो।
Yes.
ओके थैंक यू। Yes, Dr. Prashant, over to you. Please tell me, I will keep changing slide.
Hello, can you hear me?
Yes.
Okay,
Yes.
my ID is iPad because my I think I laptop has some problem, so I have joined from the my iPad ID. Okay, now can you see me? And yeah, I can see the PPT. Thank you. Okay, sorry participant for the technical glitch. This, I think this slide, yeah. Here the then there is a copyright protection, then proprietary informations. That is, what are the confidentiality kind of a clause? What is the technical know-how to be shared with the franchisee, by the franchisee holder to by the company? So that is also confidentiality clause. Then there is a misuse preventions, the prevention of the misuse or unauthorized exploitations of the intellectual property. Then infringement clause, which is address the potential infringement and the legal remedies and the ownership clarifications that confirm the franchises retain the ownership of the intellectual property right to what extent. Then next, I can change this slide or not? I mean, next slide. Okay, thank you, sir. The steps to the franchisee success. So this is the pyramid. I mean, lighting house, and once there is the initial training, ongoing training, operational guidance, the assistance related to the marketing, that leads to the. So this, I mean, as far as the contract is concerned, it is not useful for. But if it is a business expansion contract, and we are giving the franchises, from that point of view, this franchisee success model can be useful, right? Next. The next, yes, I can change, I think, right? The contract termination process. Now the end of the contract is the identifying the ground of the termination. What are the grounds on which we can terminate the contract? Because in the contract there is a very important clause called from the Arbitration and Conciliation Act. And I'll discuss the case of the arbiter, one of the landmark judgment of the Gayatri Balaswamy versus the Mac dot company. I mean, that Gayatri Balaswamy judgment, which is delivered at April 25th, 2025, by the Supreme Court, that we'll discuss, and what are the importance of that judgment, right? Then there is a issuance of the notice to notify the other party when to terminate. What is, I mean, it's like the service period or notice period from which when the contract can be terminated. Then allow the cure period, which provides the clause related to the rectifying the issues and fulfillment of the post terminations obligations, right? The next slide 31. If you look at the dispute resolution, as I told about, dispute resolutions clause, which is very important, that directly approaching to the court of law, the dispute can be settled amicably. So for that, mediation, arbitration, whether what are the grounds of the litigations, which are the governing law, and how the specific legal framework can be done. That is something which is important as far as the dispute resolution clause is concerned. Next. The next is essentials of the agreement. Due diligence. I mean, due diligence, I think those people who are associated with the CS and CA kind of thing, due diligence means they are identifying the asset liability process of the company, conducting the throughout research of seeking the legal counsel as far as the valuations of the company is concerned, valuation of the property is concerned, or the operations of the company is concerned. So that is a due diligence clause, is also important as far as this agreement is concerned. What are the balance of interest? Another side is a balance of interest on the left hand side. That is the fairness between the franchisor and franchisees, and the legal compliance which ensure the adherence to the law and the regulations governing the franchises, and the clarity and the precision using the unambiguous language to avoid the misunderstanding. Next. The next. Yeah. Yeah. Then which are the law which is generally when we are drafting the contract, which are the law is applicable. So that is in Indian Contract Act 1872, the Foreign Exchange Management Act, trademark, and so on and so forth. Next. Next. Okay. So these are the pros and cons of the franchises. Pros, the business expansion can be done, new capital can be generated, the better performance the business gets. We can reduce the cost because the company, why they reduce the cost? Because the company does not have to buy the entire property in every cities and the metro cities. So that is reducing the cost, and the risk is spreading. I mean, equally responsible. The businessman is equally responsible into the, so these are the advantages of the franchises. And cons means, which are the cons means, sometimes it is high cost. I mean, in some of the cities where the transportation and other things are difficult, like the hilly area and those kind of things, geographical locations, lots of control. Sometimes some franchises are copying our products and the services, and we can lose our technical know-how, right? Then brand vulnerability, then identity loss can be done. Me too kind of a product. In our marketing, we have a terminology called me too kind of thing. So that is identity loss. And reporting obligations is also different, because if the, when I was in GSFC, then GSFC Sardar Urea brand, which is being another small companies are writing the another name, and people and the farmer who are less uneducated, they say they thought, it is a GSFC brand. They are making some minor mistakes in the minor changes into the branding, and then the consumer feels the same brand. So that kind of thing is important to understand, right? Next, pros and cons. Then next slide is, this is one of the Indian case of the Javed Habib. I think everyone is knowing that it is a beauty salon and hair artist, and it is operated. He is operating 2 to 5 salons and training institute in 21 states and 61 cities across the India, and mostly through the franchises business. And then somebody else, I mean, we all have seen those kind of things, Javed Habib. And the format is, location, design based, number of staff, incentive, advertisement, facility, royalty, etc. So these are the, I mean, these are the points. So these are the clause into the agreement. I mean, those people who are buying the, or part of the franchises agreement, so they need to we as a legal point of view or the lawyer point of view, we need to understand which locations, what kind of a design of the format of the store, how many number of staff, what are their qualifications, what are the incentives we can give, how the advertisement, facility, and royalty can be done. So this is one of the case study which give the potential franchises the options on the various variables which stated above, and possible variations that business represent into this kind of franchises model. Next. Then there is a, these are the 10 importance drafting clause. This drafting clause is important, and first is a terms, IP, stamping, e-stamping, notarize, include dispute resolution, that is arbitration and conciliation, franchises detail, PAN number, Aadhaar, and financial details, terminations clause, GST, CGST, SGST, regulatory framework as far as the state is concerned, and the franchises can have what kind of a legal relationship with the within the particular territory. So that is also 10th is important. So this is the top 10 expert tips from the franchises agreement drafting. Then next, next. Okay, commonly drafting mistakes: the ambiguous clause, the incorrect stamp duty, missing IP protections. What are the risk and misuse we have not mentioned into the drafting clause? We are ignoring the regulatory tax obligations, and we are not mentioning the termination clause. So that is also problematic for the, so we need to avoid, while drafting the contract kind of thing, we need to avoid this major mistakes. Next. Okay, so can you do one thing? You just copy the link into the Google Chrome from your end, so that one of the franchises agreement which is open, and then I think Miss Kaur, right? She's coordinating with me. I don't think, because I am on the iPad, so it is hyperlink in the this laptop. So one particular link is open, and that is a model franchises contract agreement.
Yes, sir. One second. I'm just opening it.
Yes, sir. It's opening, sir.
Yeah, just I'm opening.
Ha.
I'll just copy it.
Sorry, sir, for the inconvenience, because my laptop is suddenly stopped, and so that's why
No, no
I
problem.
quickly shifted to iPad.
One second.
Otherwise, all the hyperlink I did in the presentation in the from the PPT to my laptop hard drive.
Yes. I hope it's visible.
Yes, sir. Yes, sir. So, I mean, I'm not doing nothing new kind of a thing, but this is something which is, if you look at, this is the model agreement where, exclusivity, the agreement herein after the agreement enter into the so and so, Andaman and Nicobar, I mean, the respective state, commencement date, the resident, and the resident herein after is a franchise. So this is important. I mean, common mistakes to be avoided, in which we have already seen that this particular end clause. We are not mentioning this. Sometimes we, or the as a the legal professions, we sometimes forget. Okay, but he is a franchisor, a franchisee, and the franchisors and the franchisees may refer the individual party collectively party. So this is also important clause to be mentioned. Whereas the franchisors engage into the business, specific business. Hereinafter, we call it as a business. Point number B. Point number B, the franchisors develop the system or the method operating the business using the proprietary services. Proprietary services and the trademark. So that is A, B. Yes, thank you so much, sir. Thank you so much. And the property mark, which is defined hereinafter the franchises of the business. Then the franchisor C clause, which says that franchisors accept and allow the franchisee operated business according to the certain terms and conditions. I mean, in this the contract drafting, according to the business, we need to understand first business operations from the macro point of view, and what part of the business process we are delegating, kind of a thing. So that is a C clause is all about. Okay, this portion of the business we only delegate as a franchisors, right? Then D clause, the franchisors provide the certain kind of a service. I mean, when we are allotting the franchises, the franchisee owner has to give the services to the, like, if the Titan is the one of the company which has the different stores in the city apart from the company showroom, then the franchisors, those who are selling the Titan product, maybe Titan Eye or Titan watch and whatnot. I mean, so they are having the certain conditions to follow, that the interior is look like this only, you can use only this colors and those kind of things. I met and interview one or two franchisors. They told that even the company will give you what colors to be used, what kind of a design to be followed, and those kind of things, and that has to be specified, right? Whereas the system includes the unique franchises, not limited to the specifications, techniques, training method of the staff, because it is operated at the local level, right? So what is the mode of training, the production methods, if there is a production method is involved, then it is applicable. Then what kind of a design color, as I told you, they are mentioning the color of the wall. Okay, this is our brand, and brand position is this, so you need to use only this two or three colors which is specified, and then those kind of things. So that needs to be mentioned, right? So that is a D clause. Whereas next is whereas the franchisors desire to establish, operate the business, wishes to obtain the license. This is licensing. I mean, license means you are giving the exclusive right to operate his business on behalf of the company. So the franchisor systems, the system proprietary mark, in order to in order to business under the franchise's guidance, right? Whereas relying on the representations of the promises to be made, it is again the agreement. So there are promises, and the goods and services, or what kind of a valuable goods and services, what are the consideration attached to the that kind of a valuable goods and services, that here is agreed and followed. Then can you just scroll it up, please? The definitions from here, sir, from left hand side there is a scrolling button. Yes sir, yes. The definition, in the definition, proprietary mark, the proprietary mark are the mark owned by the franchisors, including, but it is not limited to, the franchisor's brand mark, as well as any all other names or trademark, or the service mark, or the logos, or the dress, if the salesperson's dress, everything. I mean, commercial symbols and copyrighted materials, these all are proprietary marks. So that is, you have to define. I mean, the agreement is has to be defined specifically to those activity. Then this is also important, systems. The system shall define the conceptualization, specification, the design, marketing, operations, franchises, license of the franchisor's business, including the expenditure of the resources. This is very important. Of the financial matter when it involves the financial matter, what kind of, to what extent the particular franchisors do the expenses. This is all, I mean, working capital kind of expenses, kind of thing. Working capital plus miscellaneous kind of expenses, monthly, weekly, daily, they can make. So that has to be defined. I mean, that has to be defined. So that is also one of the clause, system clause. Then there is a new franchises business. New franchises business shall define the new business to be owned by the franchisors and utilize the franchises system and proprietary mark open to the agreement. So that is also, standard clause. The terms, I told you in the one of the previous slide, the terms of the agreement. What is the duration period and what is the end period of the agreement, that discuss more specifically, into the agreement. Then this is important, gross sales. Gross sales shall be defined as all the revenue derived from new franchises business at the regular prices before discounted. And how much discount, if the discount, if you look at the any other kind of franchises, Titan or any other, so they have the specific occasions, festivals, and the company is giving the discount across the length and breadth of the country. How many stores are, stores are available, and that particular discount is common. So that has to be defined. Otherwise, what will happen? The franchisors are having the own decision making power, and they may change the discounted structure. I mean, if you buy the product and services from the retailer, then they are able to give the 10% discount as far as the business is concerned. And if you are buying the same product from the company's showroom, then they may not be able to give the 10% straight away or straight jacket discount. So that is also, you need to define, that particular right to be given to the franchisors, right? So that has to be mentioned. So that is a gross sales kind of a clause, right? Then there is a territory. Territory shall be defined into the specific geographical location. For example, Baroda region. Then in the Baroda region, if there are Baroda region or Baroda district, it is a different territory. I mean, a district is a different territory, but still it is into the Baroda district. So it is limited to the city, urban, semi-urban, tier 1, tier 2 cities, or whatnot. I mean, so that is something which is, territory has to be defined, right? Then the marketing materials, this is important. That is a promotion kind of a marketing material, which is advertising and promotional materials. I think when in the Times of India, in the local newspaper, we have certain leaflets and those kind of things. So that is a promotional, is very much defined. This up to this section you can promote the product. Up to this section, billboard, you cannot promote the product. In the national daily you can promote the product, or in the local daily you can promote the product, and that kind of thing. So that is something which is, franchises marketing materials. Then there is a another clause 1.8, which says that operating procedure, the minimum operating procedure, which is in the annexure 1 that we'll see afterward. Then there is service. The service shall be defined in the following service of the franchises through the business provides to the franchises business. Then limited grant. So the next portion of the agreement is a limited grant. In the consideration of the franchisors paying the franchisee fee, we have discussed in the earlier slides also that what kind of a royalty or the minimum fees or those kind of things. So that has to be defined. That has to be defined into the agreement, and operated new businesses for terms on the terms and the conditions herein the franchisors has to accept. It is agreed by the party, otherwise there is a chances of dispute. And in the second part of my presentation, whatever cases I have discussed in IP related, or competition commission of India related, insurance related, or copyright related, so these all are all the cases arising and at the door of the court because of the clause is missing. That particular clause is missing and the franchisor has certain kind of a dispute. So that is the idea, right? So so that is a what kind of a grant to be new franchises, terms, conditions herein after franchises accepted by the franchisors, it is agreed to the party and the right to the further sub franchises they can give or not, so that is also defined. Second is the franchisees hereby grant the franchisee except under the terms and conditions of the agreement, which is limited to the non-transferable exclusive license to the proprietary mark and the system to the new franchises. So that is also in the limited grant you have to define. So that is a portion number 2 of the this agreement. Then third is a condition precedents. The parties uh, agree this agreement came into the effect from so and so date and set out to satisfy the franchises to the satisfaction of the franchisors. So and so date shall be force terms unless terminated earlier in accordance with the provisions of the agreement. So that is also the conditions of the precedence can be defined, can be when to start and when to. So that is the same clause. Can we go upside? Conditions precedence. Next is the reserve right. This is important. What kind of a right to be granted? Franchises hereinafter acknowledge and agree that the agreement shall no mean of the franchise's right are limited to the regards of the franchise's business. The franchisor is affiliated, patent, subsidized, and related business to retain all the right developed, operates, and agrees the franchisor is not entitled to any exclusivity or the territorial right specifically delineated from the agreement. They cannot delineate it from the agreement. They cannot do much more than the agreement. It is not into the jurisdictions of the this particular part of the agreement. Then there is a fees. I think the commitment fees and the franchises fee. Then next is the below is the advertising, the portion of advertising. That advertising advertising request, this advertising is agreed prominently display the franchise's marketing material. There are category of the material. This is a confidential material which cannot be shown to the customer, and this is a technical in nature, or this is a promotional in nature. So different kind of materials within the same kind of a product and the services, that has to be clearly defined into the advertising clause. Then franchisees agree to following guideline and the marketing, advertising and promotions connections to the new franchises business. Then the franchises may request regarding the advertising expenditure and the activity at the franchise's sole or exclusive discretionary, whether he can take the advertising decision by their own or not. So that is also important clause to be defined. Then the franchises agree to advertise the new franchises business. If there is a new franchises business within the same or other region within the same city, that is also explicitly written into the contract. Then next is the opening date. Franchises and franchisee estimated date of opening. Notwithstanding foregoing, the franchises agree to commence the operations on which date, and until franchises approved the specifications of the business adhering to the conditions of the agreement. Then eighth point is a compliance with the operating procedures. Like, when you are opening up the kind of a franchises or the stores, then there are certain municipal kind of approvals to be taken, and fire and safety kind of approvals to be taken. So that is also the compliance operating procedure. So that is also part of the agreement, right? So can we scroll down to the another clause? I'm not reading each and every clause and each and every clause, but you need to understand the compliance with the procedure means local municipal authority or the state authority or the central authority. Then data protection and privacy, it is agreeable to the Data Protection Act 2023, DPDPA, right? And the personal data, what is, the right is arising out of what is the privacy and what is a private data, that has to be defined. Like, if you're asking me my name, so it is a private in nature or not. In the franchisee agreement, you can tell the main company's name. So that is a what level of privacy you can take. So that is a data privacy clause. Next is the employment and labor compliance. So that is local. When the local labor is to be hired, then what is the qualifications? Like, in Javed Habib case, they are only hiring the BCom and MCom kind of staff for haircutting. And when I have visited and inquired, then the minimum qualification is bachelor degree or master degree. They have their kind of a franchises agreement, and that we need to understand from the company, and what is the requirement from the franchises, and what company is expecting from the franchises to do. So that according to that, we need to understand the employment and labor compliance within the state, right? Then there is a terms and terminations. So that is the ending period 11, the point number 11. And the next, you have to explicitly mention the expiry date of the contract. And there is one particular clause in the same, there is an arbitration clause. And the right and obligations of the termination, which is very important. Who has a first right to terminate the contract? Franchisors or the franchisees? So that is also you need to define explicitly into the clause. In case of the bankruptcy or insolvency, or new business, if you are starting, if you are occupying into the physical space where what kind of a terminations to be done, and if you are having the felony or the criminal offense or the misconduct at the space of the franchises, how the company is dealing, that explicitly mentioned into the termination kind of thing, right? And then there is a right and obligations of the terminations, the 12 number. So that is a right and obligations of the terminations. I'm not going into the much detail of the right and obligations. That is again depend upon the nature of the business, what kind of a right, what immediate ceases to the property mark or the systems, or infringement of the copyright. So that kind of a clause to be included into the right and obligations as far as the terminations of the concern. And then there is a renewal, right? So renewal at what time? So you need to understand after how many months this particular contract is exist, and how we can enter into the new contract kind of thing. Now, can I back to my original PPT? So this is the main contract drafting kind of things we need to take care while drafting the franchise. Sorry, sir, I'm giving you the trouble in between. Okay, so next is the that sample PDF I will share separately. Then slide number 40, 40 reinterpreting. This is that this particular case I just wanted to discuss with you. It is a classical case of uh, you know franchisee agreement, where there is one particular clause is arbitration clause. And this is a recent judgment when I was reading. And this judgment was because of this, there is a felony into the franchisee clause. This judgment is delivered by the Sanjeev Khanna, Honorable Justice Sanjeev Khanna ji, Mr. Honorable Chief Justice of India, B.R. Gaveji, Honorable Justice Sanjay Kumar, and Honorable Justice Augustine George Messi. So this judgment was delivered on 25th of the April, and in this the issue is arising out of the the ISG Novasoft Technology Limited and Gayatri Balaswamy versus ISG Novatech, where there is a clause into the agreement. Yes, modifications of the arbitral level. Yes, that you are right. And in this, the court has asked very crucial questions that what kind, is it within the power of the court to modify? Point number one. Point number two, the already decided award can be modified. If yes, then to what extent it can be modified? Then what is the meaning of in section number 34 of the Arbitration and Conciliation Act, this to set aside the award? So what is the meaning of the word called set aside the arbitral award? So that is one of the third questions the Supreme Court, in the Supreme Court, it has been decided by the four judge constitution bench. Then whether the power to modify the award is read with the power to set aside under the section number 34 of the act, and whether the judgment of this court, when Supreme Court, in the National Highway Authority of India versus Hakim, that judgment is very interesting. In that judgment, because of this particular dispute when arise, then one particular gentleman Hakim has approached to the Supreme Court, where his land acquisitions, where his land is taken by the government because of the development of the highway. Then in that, the Supreme Court has in the Supreme Court, the issues discussed that it is within the power of the court, or within the jurisdictions of the Supreme Court, that the land can be acquired if the particular land is intended to use for the public betterment purpose. So that is the case. I mean, that is the case. And when section 34 in the learned council in the Hakim versus NHI case arbitration clause, because there is a faulty arbitration clause. I mean, not faulty, I would say, but the one particular clause which says that in case of any dispute between the two businesses, then we will amicably solve through the ADR, alternate dispute resolutions mechanism, and we will not go to the court of law, and we will mutually decide the award. So that is I would request all the participants to read. I have read this particular judgment, the Hakim and NHI versus Hakim, and this Gayatri Balaswamy, and very interesting interpretation. And at the end, what in this Gayatri Balaswamy versus this ISG Novasoft, what are the conclusions? So let me tell you that it is according to this judgment, the award is surveyable, but court has no power. Court has no power to enter into the modification kind of a thing. That is point number one. Point number two, court is saying that now what is the court's powers? Then the award which is being written, the court has a power to bifurcate into the valid terms in the sentence, in the award, and invalid terms. So the Supreme Court can delete the invalid terms, not the valid terms. So that is the power of set aside. I mean, in Hakim, NHA, National Highway Authority of India, and this versus Hakim case, the court has said this set aside also include modification power of the court. But in Gayatri Balaswamy case, the court has said that it is not the jurisdiction of the court, and that is the reason the ADR Act is being enacted. Second point, which is Supreme Court has said that the court has only power to delete the invalid part in the award and admissible the valid part. So that is a power, not modified, right? Second power is by correcting any kind of a clerical computations or typographical errors which appears erroneous onto the face of the records. So that is also the power of the court. Second, third, post award interest can be modified, but provided according to the Indian Interest Act. And fourth thing, the court has said that under the Article 142, the Constitution applies. The power must be exercised by the court with the great care and cautions within the limit of constitutional power. So that is the case of I mean if you talk about the, and I'll discuss one of the case. Can next slide please, 41 slide 41 slide number 41. Okay, so this is the whatever I have discussed, that is the same descriptions, right? Next I'll coming back to the setting aside, that is already discussed, arbitral award. This is a statute language. And then appeal this section 37, appeal. This appeal on which ground, and when this particular clause is ADR clause is introduced, then there is a the court has actually I mean in the particular judgment has referred to the other countries arbitral award, like Singapore, UK, United States of America, France, Australia, where how the particular arbitrations can work, and how they are resolving the ADR kind of thing, right? So that is also the court has looked into the Gayatri Balaswamy and in that particular judgment. Next, please. Next, sir. Because I already discussed. The key findings is already discussed. Then next is the one particular case which I would like to discuss is Amazon and Future Retail Group. I think it's in the next coming up the slides. So Balaswamy is this case. If we can, sir, open up this first, then it is. If not, then it is also fine. I mean, I can discuss orally also that particular judgment. And in the Amazon and Future Group, when they are entering into the business in 2019, I'll share the copy of the agreement to the sir. So if those participants who interested to read that particular copy of the agreement, they can access. In that particular judgment, the Amazon versus Future Group, where the clause is involved, there is a seat of arbitration is into the Singapore. And see, on August 12th, 2019, Future Group versus yes, this is this is, sir, yes, this is a agreement copy, sir. So I mean, I'll send it to you. But as of now, I think I cannot read the every clause. But this is important. I mean, which I have included it. The Future Group and Future Retail Agreement, what Future Group is Kishore Biyani Group and Big Bazaar and those kind of things, right? So they have the agreement that I'll not go into the I mean, this is a timeline. August 2019, what happens? Amazon and Future Group entered into the retail agreement in August 28, 2019. Then Future Group, Future Retail and Reliance sales agreement was happened on March 20. Then on October 20, the Delhi High Courts Delhi High Court has permitted that the Singapore seat of the arbitrations, that is seat of the arbitration in this particular case is the Singapore, so allowed by the Delhi High Court. And then in December 21st, 2020, the Delhi High Court, CCI, SEBI and NCATL has passed the certain orders. On January 25, 2021, Amazon sought the enforcement of the Singapore arbitration award. Singapore, this arbitration award. And January 26, the Future Retail approach to the NCTL National Company Law Tribunal, and on February 2nd and March 18, 2021, Delhi High Courts upheld the Singapore Arbitral Award. I'll explain. This is just a timeline I'm just showing to the participants so that they can able to understand what is the timeline of the particular case. And Supreme Court allowed the NCTL to continue with the process. And now it is very interesting. Now, what is the agreement is all about? I mean, Future Group and Amazon in this particular case. Once in the past, the Amazon has a particular contract with the Future Group, and they have one particular clause called first right to refusal. I mean, I'm repeating once again, first right to refusal, quote unquote. So that particular first right to refusal, that particular clause is related to that whenever in future, even this particular agreement is not exist, business agreement is not exist, even then when you are selling your entity, business entity I'm talking about, then that particular business entity you have to first offer to us. I mean, it is very interesting in law that they have not used the word first to offer. Instead of that, they have used the word right to refusal. First right to refusal, which means that you need to offer. And if they refuse, then you can go and find out and sell those entity to the other vendors. So in this case, the Reliance Industry Limited has already done the agreement. Reliance will buy all the big bazaar stored across the length and breadth of the country. And then Amazon US has invoked this particular arbitration clause as per the agreement. And they approached to the Delhi High Court. And Delhi High Court, and in that particular agreement, there was a clause that arbiter, if any dispute is arising out into the future related to the first right to refusal, then they are sitting at the Singapore sit. Unless Singapore is one of the geographical locations they have decided. And that particular Singapore, in the Singapore, both the party will sit together and decide what kind of course of actions we can decide. So that is something which is, first right to refusal, and this clause is being violated by the Future Group, means Kishore Biyani Group. And then the Amazon lawyers and the US lawyers, and they have the nexus in Indian Supreme Court, and they are hiring the top-notch lawyer kind of a thing, and they have found out that this is the lacuna where this particular Future Group cannot be sold first to Reliance Group, right? And then the Delhi High Court has upheld the decision. They can, because as I said that in the Gayatri Balaswamy judgment also, it is not the jurisdiction of the court. As far as the arbitral award is concerned, there is no jurisdiction of the court. If the arbiter is dissatisfied, then they can approach to this court of law. Then in this first right to refusal, they fought the case, and somehow this particular decision is being in the favor of Reliance. But the idea is that, if imagine the hypothetical situations, if the Amazon is owning the entire big bazaar business, then they have absolute monopoly kind of a thing as far as retail or FMCG market is concerned. And that particular business is straight away goes to the foreign company, and somehow the East India Company in 1600 has the agreement is similar kind, and we are under the colonial rule because of the company, one of the company's agreement, and they are controlling the entire country through in the name of the business, and so on and so forth, that so these are the these are the things you need to understand, that first right to refusal, the clause, how they can play, how they can use for the for their own interest purpose. So I think these are the inputs as far as the whether it's a distribution, because this case is related to the distribution. Because if the Amazon is owning those kind of things, then they are through the big bazaar, so they are distributing their product and services, right? So this is the case related to the distribution into the, and that is being decided. This much is from my end. If any questions from the participant, then with the permission of the sir, Kalpesh sir, and the organizers, how they can ask, or they can unmute, or they can type into the chat box, whatever is the rules and regulations that we can follow. I mean, and this is from my end, sir. I mean, these are the submission from my end.
No, I would certainly agree. It was an exhaustive presentation. You prepared an explanation. Then tried to cover so many things, right, with the help of cases or various cases and case studies. So participant, we can take quick one, two questions, maybe if possible, because already it's 8:25. Yes,
Yes,
anyone
sir.
like to ask any question? Please raise hand or anything. Yes, let me ask question. I think participants. So if they are not following, if we have like in Vadodara we have Mr. Puff. If
Yes.
we are not following, because different kind of franchises there. Sometimes they just sell things. Sometimes they do. I was explaining this thing to my elder son, how they operate. Like Atul operating something different thing. Get the stock, they sell. Some places they have to teach, like they have to equip them how to make food items like dominoes, other things, give the training, because that is very different thing. Any question, participant? Just we are just explaining. So
Thank you.
any
Thank you.
sure. Thank you. So
Uh,
any
because people, I mean, participant writing, it's wonderful session. So I'm just acknowledging
no, no,
the thanks to them. That's the reason.
sure, thank you. And
Thank
different
you.
kind of, yes, Amit,
Thank you so much, sir. And on behalf of Sambhav Initiative and Pro Bono India, I would like to extend a sincere gratitude to you, sir, for delivering such a thoughtful and enriching session today. We are truly thankful to you, sir, not only for accepting our invitation, but also for taking time to guide and inspire all the participants today. Thank you so much, sir.
Thank you so much. Namaskar to all the
namaskar.
participants. Thank you so much. Thank you so much.